This season, Instacart has your back to school. As in, they've got your back to school lunch favorites, like snack packs and fresh fruit. And they've got your back to school supplies, like backpacks, binders, and pencils. And they've got your back when your kid casually tells you they have a huge school project due tomorrow. Let's face it, we were all that kid. So first call your parents to say I'm sorry, and then download the Instacart app to get delivery in as fast as 30 minutes all school year long. Get a $0 delivery fee for your first 3 orders while supplies last. Minimum $10 per order. Additional terms apply.
Getting the smile and confidence you've been dreaming about, all from the comfort of your home, isn't a total mystery with Byte clear aligners. Just don't be surprised if all your friends start asking, "What's your secret?" Begin by ordering your at-home impression kit today for only $14.95. Byte clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces, plus they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Have you ever covered a carpet stain with a rug, ignored a leaky faucet, pretended your half-painted living room is supposed to look like that? Well, you're not alone. We've all got unfinished home projects. But there's an easier way. Thumbtack is the app that makes it easier to care for your home. Pull out your phone and in just a few taps, search, chat, and book highly rated pros right in your neighborhood. Download Thumbtack and start caring for your home the easier way.
Content warning. This episode includes discussion of the murder of 2 children.
Hi, everybody. Thanks so much for joining us today. So it's been a little bit quiet in the Delphi murders case recently. Of course, I'm referring to the murder case against Richard Allen, who stands accused currently of murdering 2 teenage girls, Abigail Williams and Liberty German, in the town of Delphi, Indiana, back in 2017. So there was a flurry of activity. We all thought we were getting ready for a May trial. Spoiler, that did not happen. But things kind of eased off at that point. But just recently, we got 2 new orders from Judge Frances Gull. So today we're going to just be talking about those 2 orders and what they mean. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders. Judge Frances Gull issues orders.
So I don't think either of these 2 orders is a shock, but let's go into them. One of them is about something very fundamental, very important to the future of this case, which is which judge will be handling it, because Judge Gull was asked to recuse herself. The other order is, frankly, much more trivial.
So let's start with that one.
Yeah, so let's lead with that one.
Lead with the boring one.
Well, it's not necessarily boring, but it's just really
A stupid sideshow.
Like
so much in this case. So on May 31st, but by the way, both of these actually, they were dated May 31st, 2024, but they appeared on the docket on June 3rd. And there's usually like a bit of a delay, so that's not, I'm just being overly detailed as usual. So this order was in response to David Hennessy's petition to strike gratuitous and demeaning commentary and or findings from contempt order. Although she did correct demeaning for him, so that's good.
He misspelled the word demeaning when he filed this. Basically, I'm sure most of you, if not all of you, remember this. There was a contempt hearing, and Hennessy specifically said, I don't want you just to say whether or not you hold them in contempt. I want you to really spell out your findings. Judge Gull spelled out her findings, and in those findings, she said some things that David Hennessy thinks were mean.
that the defense attorneys for Allen, Andrew Baldwin, and Bradley Rosie are basically incompetent, sloppy, words to that effect. She did not find them in contempt, but she basically said that they did a bad job handling a lot of this. And so even though he asked her to be very detailed in explaining what her thinking was, when it was something negative to his client, Hennessy, of course, said, that's too mean. Be nice.
Take out the mean stuff.
Be just super nice to the boys. And
Judge Gull's response to this is so short. I think you, Anya, can read it basically in its entirety.
Yes. So she wrote, quote, defendant claims the court directed the Carroll. Oh, wait, I'm sorry. I'm jumping way too ahead of myself in my notes. This is actually even shorter than that. So, quote, the court has reviewed defense counsel's petition to strike gratuitous and demeaning commentary and or findings from contempt order filed May 8th, 2024. As the court granted counsel Hennessy's motion for specific findings of fact and conclusions thereon, filed on March 12th, 2024, this motion is denied. End quote. So basically 2 sentences saying, this is what you asked for. Thanks for coming.
You asked for it. Now you're telling me to take it back. No, you asked for it. I gave you what you wanted. So long.
There's a lot of hypocrisy that kind of tends to happen in this case, and this is one of those things. It's like, okay, be very detailed, but the details are something that we find somewhat unflattering, so actually don't be detailed. I mean, like, I guess maybe there's a perception that people aren't following this, but we are, and I just think it looks bad.
And all of you listening are.
like a lot of this wouldn't be surprising to me if it was just like there was a perception of like no one's paying attention, but again, I just think it just looks, it's embarrassing at a certain point.
So the other order filed was the defense filed another request. I believe this may have been like the third request for Judge Gull to recuse herself. And they listed some reasons why they thought she should recuse herself. And they said, we really like to have responses to each one of these. And so she goes through and gives her responses to, in the order she filed, she gives her responses to these specific claims of the defense.
We'll just go through the whole thing, read them, and talk about the points. She's making the points that were made by the defense and sort of where everything stands here.
And who we think makes the most sense there or what have you.
Yeah, and kind of, and there's actually some intriguing elements to some of these that we don't really know how to interpret, so we're going to be talking about that too. But should I give a spoiler alert? She's not recusing herself. So, I mean, that
I don't think anyone really expected her to.
No. You have the defense attorneys who say she's so biased against them. And I think there's another side to that I think, maybe she's not biased. Maybe she's trying to rein in some pretty bad behavior on their part. And I don't know. So people have their own opinions. People kind of go back and forth. But in this, she's kind of outlining why she does not believe she recused herself.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
What makes a life a good one? Is it the adventure you have? Or the friends you find along the way? Maybe it's pursuing your passion while striving to protect, defend, and save what you believe in every single day. So, what makes a life a good one? In the Coast Guard, we think it's all of the above and more, but you'll have to find out for yourself. Visit gocoastguard.com to learn more.
You've worked hard to build your brand, so why settle for one-size-all-fits branded clothing? Lands' End Outfitters creates apparel your employees will truly want to wear that unites your team in comfort and style. It's clothing that bolsters your brand identity and creates a unique connection between your brand, your employees, and your customers. It's why Lands' End Outfitters has been a supplier of branded apparel to some of the world's most respected brands for more than 30 years. From logo polos to fully customized branded wardrobes, our world-class outfitters will partner with you to help your team feel confident on the job and put your brand into action. From logo application to online ordering, Lands' End Outfitters offers seamless solutions that give you peace of mind, all backed by above and beyond expertise. See why Lands' End Outfitters should be your branded apparel partner. Go to business.landsend.com/pod20 and use code POD20 for 20% off your first product. That's business.landsend.com/pod20. Code POD20 for 20% off your first product.
Why don't you read the first claim that she responds to?
Yes, this is what I was starting to read before, and then I was like, I'm way too ahead of myself. Quote, defendant claims the court directed the Carroll County Sheriff to ignore subpoena. The court directed an email to counsel on June 14th, 2023, regarding the witness refusing to cooperate with the service of the subpoena and demonstrating willingness to fight the deputy attempting service. Court requested report of the witness's refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. End quote.
So this is about what happened close to a year ago with Robert Bastone. He is an inmate at Westville, where at the time Richard Allen was also incarcerated. He'd made some claims in a letter concerning Richard Allen's treatment. He was subpoenaed to appear at a particular hearing. When the sheriff went there to get him so he could attend that hearing, he refused to leave his cell. And so the defense says, well, even though he refused to leave his cell, he still, I guess, should have been forced to come. And it was wrong for the judge to tell the sheriffs not to forcibly remove him from the cell. And in her reply, Judge Gull is saying, no, that's not what happened. I did not tell the deputy not to forcibly remove him. The deputy made his own choice.
Right. And one thing about this is that I think it's really important not to get lost before we keep on talking about this versus what the deputy says, because this discrepancy is there. But Robert Bastone is a convicted child molester who has done things like shame his 6-year-old victim, file frivolous and bizarre legal filings in his case talking about how he should be released from prison for his crime because he can help win the war against COVID-19.
So this is a guy with very least
no credibility,
serious character and credibility
also,
issues.
We've corresponded with him, and in my experience, he basically uses high-profile cases as a bait and switch to say, hey, I can tell you all about Richard Allen. Reporters go, what's up? Actually, talk about my case. The biggest injustice here is what happened to me. That's what we're dealing with here. So, I mean... But
with all of that said, that's not what the issue is.
I'm not saying that's what the issue is. I'm just saying people need to keep that in mind when we're talking about this person.
The issue is the defense says that the sheriffs went to the cell to serve a lawful subpoena on this man. This man refused to come and appear at court, and the judge said, deputies, don't worry about it. Just leave him there and come back. And they said that's improper, that they should have been brought into the decision. And Judge Gull is saying, no, that's not what happened. What happened is the sheriff on his own made the decision not to forcibly remove this witness.
So why don't you read what the deputy previously said happened?
Yeah, this is troubling because as someone who follows this case, I was aware of the deputy's account of what happened that day, and it doesn't tally with what Judge Gull says. Quote, on June 14th, 2023, I, Special Deputy Wisaki Bryan, while on duty, was conducting a court-ordered transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to inmate Bastone Robert, segregation unit, to conduct the pickup. After waiting, a corrections officer approached me and told me Bastone is refusing to come out of his cell and told the corrections officer, F you can't make me go. The correction officer told me they will have to do a cell extraction to get him to my transport vehicle. I told the corrections officer to stand by to let me make a few phone calls. I was escorted back to the main gate where I was greeted by Warden John Gallupo. I called Carroll County Jail Commander Laura Sestaric, who I explained the situation to. She then made a phone call to Chief Deputy Tobe Lesenby, who contacted Judge Frances Gull's office to inform them of the situation. Judge Gull's office advised to leave Bastogne there if he did not want to attend the court hearing that is scheduled for 6/15/23. I then spoke with Warden Gallupo and asked if he could provide me with a letter stating that Bastogne refused to come out of his cell and that he did not want to go. Warden Gallupo agreed he would. He later advised he would bring me the letter, end quote. So the deputy is saying there, I contacted through Lesenby. We contacted the judge's office and were told we could leave him at the cell and that she just wanted a letter. And Judge Gull is saying, I asked for the letter. They made their own decision there about whether or not to remove him from the cell. So that's a discrepancy.
I mean, I don't know that it is when I'm reading this. I think there's a possibility that both of these people could be reciting events to the best of their ability. And what I'm talking about specifically, if he said, I called Judge Gull and she said this, then we would have a huge problem here, in my opinion. But one thing that I'm noticing is that he called Sestaric, who then called Lesenby, who then called vaguely Frances Gull's office. What does that mean? Is he talking with somebody who is in the room with the judge and kind of translating what she wants? Is he talking with just somebody who's like, well, I don't know. Like, I guess he can't go then. I mean,
that's an interesting point, but Gull says that she requested a report of the witness's refusal to cooperate. And then we have the deputy asking for and getting such a report. So there seems to be some sort of a concession there that there was communication going on between Gull and this deputy prior to the time that this deputy left the prison without Bastogne in his custody.
I'm just saying that I think when there's a game of telephone going on, I'm willing to kind of basically say, I don't know what happened until I get more information.
That's fair. I don't know what happened. There's all sorts of possible explanations. She could have said, well, you do what you want to do, but if you can't get him, get a letter.
Yeah. I mean, it's basically impossible to say.
But we always try to be completely unbiased here and point out discrepancies, no matter which side they might hurt. And this is a discrepancy. Yeah.
Or at least it has the appearance of one. And I think that's important to point out. And I think it's also important to note that when it comes to, I guess, the deputy's recounting is more detailed and has more pieces. So it would have been nice to maybe have a little bit more of a sense from the judge's side about what this looked like. So then maybe we could get details where we could assess more in depth about what happened.
Yeah, I agree.
And I mean, at the end of the day, I'm curious what your take on this is, Kevin. But do you feel like the judge had an obligation to basically say, like, tase him and drag him out bodily? Or like, what are the rules around that?
Well, judging from what the deputy wrote, it sounds like the people at Westville were at least giving him the option of a cell extraction. I don't know what exactly a cell extraction is, but it seems to suggest that it would involve forcibly removing Bastogne from his cell to forcibly bring him down to Delphi to cooperate. I think problems there would be that the defense attorneys have consistently made lots of very strong arguments about prisoners being mistreated, and it is hard to imagine how you could do a forcible cell extraction without mistreating or being a bit rough with someone.
So basically they want them to brutalize this prisoner so that they can basically say, well, there you go. That's what we're talking about. Yeah, that's what it kind of reads as to me, frankly, because it's all about prisoners' rights until it's something like this all of a sudden. And then it's basically like, drag him out of here. And that doesn't seem like a safe situation for him if he's, again, this is somebody who inserts himself into this case and I think has very minimal to contribute.
It's very much a sideshow because I don't
believe anything he says.
Yes, we had some letters we had with him, as Anya mentioned. I guess more accurately, emails with him. And we've looked at his record and his previous attempts to file cases. This guy doesn't have a good record for telling the truth. I think if he had come up there and testified, he likely would have done more damage to Richard Allen's case than help.
Yeah, he basically helped them out here by having them be able to complain about something. So, I mean, it is very much a sideshow.
And to be clear, I think you're probably right. There probably is an explanation for this.
I could be wrong. I mean, I just want to see more information, I guess.
But on the record, based on the reports we have, there's a discrepancy. I'm sure there is probably an explanation for this discrepancy, but I'm just pointing out these accounts don't match.
Yeah, they don't match. And again, I feel like the deputies is more detailed. And so it would be nice to see that from the other side.
Yeah, the deputies is much more clearly written. And I think there's some...
Like, here's exactly what happened point by point.
Yes. And I think later on when we read some other parts of this order from Gull, there'll be some things that we are concerned aren't as clearly written as we would have liked.
That's correct. I find that some of Gull's orders the wording can throw me off. Maybe I'm just dumb and not used to reading legal documents, but there's some things I have to read a couple times to just be like, oh, that's what she's saying. It can be it's not like necessarily, I wouldn't say it's poorly written. It's not that. It's just, it can be a bit opaque, the meaning sometimes.
And I don't know Special Deputy Brian Wysocki, but all it took for me was just to read this once, his account, and I understood it perfectly. It was very clearly written and concise.
There you go.
What's next?
The next piece is about...
Why don't you read it?
Ex parte stuff. Quote, defendant claims the court engaged in ex parte communication with the Carroll County Sheriff regarding defendant's housing, transportation, and safety during jury selection and trial May 13th to 31st, 2024. These communications were administrative in nature and did not address any substantive issues. Communications were directed to where the defendant would be housed during the trial and who would be conducting transportation. The court did notify counsel where defendant would be housed during the trial, as he is still under the safekeeping order, in an email, but did not inform counsel of the communication as nothing substantively was discussed. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel the hearing upon the filing of this pending second verified motion to disqualify, end quote.
So they were basically saying, the judge communicated with Carroll County Sheriff's Department without letting us know that's improper. And she basically makes the point that we made on our earlier episode about this, which...
She specifically had an issue they specifically had an issue with her discussing with Carroll County Sheriff Tony Liggett, who they're saying, he's a witness in the case, you can't talk to him. I thought their argument was wholly unreasonable. Sheriff Liggett it's his job to oversee transportation of Allen during these hearings. He is serving a logistical purpose, which he was elected to do by the people of Carroll County. That's his job. It's the judge's job to help coordinate that. They have to talk. This is what, I mean.
Yes. So it's not, so to be clear, obviously there are many cases where if a judge talks with a sheriff, even if Judge Gull talked with Sheriff Liggett, it would be improper.
Yes.
Like if she communicated with Liggett and said, okay, here's what I think we should have Richard Allen say or do.
Or, hey, here's how I would change your testimony in order to be more beneficial. I mean, yeah.
Yes. So if she was talking about the substance of the case with a witness, that is improper. But she was not talking about the substance of the case. She was talking about administrative and logistical things related to Sheriff Liggett's job.
I'll even go further. There would be cases where I would say, like, if the judge is suddenly talking to the main detective, it would really be a huge red flag for me, because I would be like, wait, why are they talking? They have no reason to talk. That's really suspicious. But in this case, there's no mystery. Liggett's not some random detective. He's literally the guy in charge of transportation here. So they have to talk. There's nothing suspicious about that. If there was some sort of element of this that Kevin mentions as like talking about substantive case issues, then that's a different concern.
Yeah.
Then that is a concern, frankly. But it's just pretty self-explanatory, frankly.
Okay, I'm going to read the next section. Quote, counsel claimed the court invited the state to limit defendant's Sixth Amendment right to present defense. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28th, 2024, end quote. So there was an email that Judge Gull sent to the attorneys in the case in which he mentioned something about third-party perpetrators and whether or not evidence involving alleged third-party perpetrators would be involved or would be allowed into the case. And third-party perpetrators, this is just a fancy way of saying it deals with whether or not the Odinism stuff can come in.
People might be wondering, why would that even be in question? Isn't that what the defense wants to do? Shouldn't they be allowed to do that?
Well, the thing is, you can't just have a situation where a person can walk into a courtroom, a defense attorney, and start blindly accusing anyone under the sun. You have to prove that the person you are accusing, if you're saying this person did the crime instead of my client, you have to have evidence that that person did the crime. There has to be something that places them at the scene or in something tying them to it. You can't just pull something out of your hat.
So I can't, if I'm a defense attorney, I can't just go in there and then look in the gallery and you're sitting there and say, that man did it,
Yes.
like without anything.
So in her email, she made a comment about that. Shortly after that, Nick McClelland filed a motion to limit the use of third-party perpetrator stuff in the trial. And they were saying, well, obviously, he only did this because Judge Gull gave him the nudge to do so. And I guess they believe it wouldn't have occurred to him otherwise. But the fact is, behind the scenes, reporters, lawyers we talk to who are not involved with the case, but who are qualified criminal attorneys, everyone predicted that McClelland would be filing such a motion. And if you read the motion that McClelland filed, it obviously was not something he hastily prepared after reading an email from the judge. So I think everybody predicted that this was coming.
Yeah. What did you make of their argument that she must have inspired it? It seems like it's sort of intended to demean the prosecution. Like they're just getting their cues from the judge. It's not, they can't think of anything on their own.
Certainly the undertone of quite a few filings from the defense. I'm trying to phrase this carefully. There's an undertone from some of their filings. They don't seem to have a lot of respect for anyone's competency other than their own.
They have a lot of respect for their own, though, so I guess they make up for it with that.
But they don't seem to respect Nick McClelland, and they don't seem to have a lot of respect for Judge Gull.
That's very clear. But in this situation, I thought it was a rather weak argument because, as you said, this was like one of those things that was like a waterfall on the horizon. Like, we're about to go over Niagara Falls. We can all see it coming. We all know that something's going to be done, whether you're going to lean into it or turn around.
And when we talked with lawyers behind the scene, again, lawyers who aren't directly involved in this case, they're saying, oh, we don't even think the Judge will be allowing any of this Odinism
stuff. Lot of the refrain from people that we speak to, again, some of them are in Indiana. A lot of them will never even appear on the show. They're just people we talk to on background. But a big thing we heard from defense attorneys was basically like, I don't know if any of this will be allowed in because there are rules about third-party stuff that you want to abide by, and it's possible that some of this stuff is so frivolous it will just be thrown out. And so when you have people who are not involved who are just kind of commenting to us and saying like, I wouldn't allow that in, then I imagine it's on everybody's mind.
And this is a ridiculous example, but Anya is charged with stealing cereal.
Again.
And is her defense going to be, I didn't do it, it was space aliens? That's not really a defense that's going to be allowed into court unless you can produce evidence that, first of all, space aliens exist, and number two, space aliens were in the neighborhood of the grocery store at the time and had the opportunity to commit the crime. You have to have some factual basis for the alleged third party to be guilty of the crime in order to rise to the bar where you can mention it in court. Otherwise, you're just potentially smearing people who had nothing to do with the crime, and you're also dragging out the process for no good reason.
What if I told you the grocery store was in Rosedale?
That would have been a very funny line if you remembered that the town you're thinking of is actually Roswell.
Oh my God.
So you just completely blew it and embarrassed yourself.
Again?
Let's quickly move on.
This is my new Kato Kalin thing. I'm sorry, I don't know about aliens.
I'm going to read the next section so we can forget Anya's humiliation.
My blunder.
Quote, Counsel claimed the court has disparaged them and ruled on defense pleadings without hearings. The court's comments about counsel's performance were documented in the court's order of April 30th, 2024, regarding their handling of discovery materials. If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require hearing, end quote.
So essentially, I made a record. It's up to me to decide whether or not your claims and filings rise to the level of requiring a hearing. And I mean, is that your reading?
Yeah.
And another thing at this point in the document, I think it's interesting. She's not really rising to the level of the bluster that we've seen from some of the defense. A lot of this is very matter of fact so far. Things might get a little different later, as a heads up. But I think right now it's just very matter of fact, very dry sort of filing.
I'm going to read this next section, which is a section that I think we tried to read a few times to try to figure out what she is saying here. Quote, allegations the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18th, 2024 hearing. The court was notified on May 20th, 2024 of an inquiry by the Indiana State Police to the court reporter via email on May 9th, 2024 regarding ex parte communication received by the court from Gary Bodette, which was previously provided to all counsel. The court is unaware of the extent of Indiana State Police investigation, end quote. So the big news there seems to be that the Indiana State Police is conducting some sort of investigation of communications sent to the court by Gary Bodette, who online uses the name Big Solves.
So he wrote to the court on March 11th, 2024, and we can go over some of his letter to recap for people who are not like, there's so many moving parts to this filing, so we're trying to give you as much context as possible. But with this is essentially a YouTuber who the defense has held up as, no, it wasn't the Mitch Westerman leak, that happened, but also Nick McClelland was clearly leaking to this YouTuber as well. And that is kind of how he fits into this case. And is that pretty much it?
Yeah, in the letter that he wrote, he basically said that he'd done nothing wrong, and he did some word salad in the letter. I'll read some of it. Bodette writes, the allegations regarding my interactions with certain individuals online have been significantly misrepresented and possibly altered by the accusers or their associates. I wish to clarify that any of my actions, which have been incorrectly interpreted as factual by witnesses, are actually misrepresentations of the true circumstances, unquote. So that's kind of hard to figure out what he's saying. Again, I think a lot of people could really stand taking writing lessons from Special Deputy Wysocki, because what he wrote was very, very clear. A lot of people think, well, if I use words with a lot of syllables, it makes me sound smarter. And you don't sound smart if people can't figure out what you're saying.
Yeah, I'm a little bit confused about this too. I guess, I don't, but honestly, I'm kind of confused about what the judge was saying here. So I think we both looked at it a couple times. We think that it means that ISB is looking into some of his correspondence, but what exactly that means, we don't know. I mean, I will say that Mr. Bodette also included a Google Drive folder that seemingly, from what I'm reading, had to do with a lot of compilation of information around Angela Sadlowski and Courtney Parsons, two other YouTubers who have been like harassing people in this case and sort of carrying on in that way. So I don't know if it has something to do with that or it has something to do with possible leaks involving Mr. Bodette. It's hard to say.
There were all sorts of allegations that Mr. Bodette was involved in improper leaks and was spreading information that he shouldn't have been spreading. So it's
by the defense, yeah.
By the defense, it's confusing. It's confusing, and I don't know. There may be not much to this, or it may be something that we're not aware of. But why don't you read the next section?
Sure. Quote, defendant blames the court for ex parte pleadings which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state, but not the public. Counsel's staff contacted this court staff and were advised that the statewide Odyssey case management system, not DocsPop as alleged in the pleading, has distinct process for filing pleadings ex parte as opposed to confidential. The court did email defense counsel a tutorial paper authored by JTAC explaining the process. Since that communication, defense counsel have had no issue with their staff properly filing ex parte pleadings.
End quote. So quickly, what this is about is that there were some documents filed that were supposed to be filed by the defense in such a way that they didn't want the prosecutor, Nick McClelland, to have access to them. He did get access to them, and so there's been a hue and cry raised, largely by the defense, about whose fault this was. And here, how did Judge Gull?
I mean, this was brutal. This was a brutal paragraph. I mean, she's basically saying that they or their staff don't know how to do their jobs properly on this Odyssey system, and that, basically it was their fault. They filed something under confidential when it should have been ex parte, and they have no one to blame for this but themselves.
And after they were helped by getting a tutorial, the problem has not happened again.
I think that it's really embarrassing, and the whole thing about the tutorial is pretty devastating. When basically, if I had to hand Kevin a tutorial on how to be a good podcaster, and then I made that public, you'd probably be somewhat embarrassed. I sometimes feel like I have to write you a tutorial about mic discipline, because you always end up, you can't see this, everyone, because this is an audio only program, but half the time we're talking, and by the end of our conversation, he is like out in the hallway away from his mic, because he's just leaning away and this way and that way. And fortunately, that's what audio, editing software is for. But
so it doesn't get picked up when I do that. So it just fools you all completely in thinking I have great discipline.
But basically, Judge Gull said, this is a skill issue for you, for your team. This is a skill issue. This is on you. Nick McClelland's not sneaking around the bushes, pulling a Mitch Westerman and breaking into the defense headquarters in order to, figure out what filings they're doing. You just don't know what you're doing. You don't know how to handle like a basic, Odyssey situation, and look into that before you try it again. And they did, and now it's all fixed.
Let's move on. Quote, accusations of violating rules on access to court records have been completely explained and dealt with, including by the Indiana Supreme Court in the first writ of mandamus filed by defendant, end quote. So basically she's saying you made complaints that I filed and handled records incorrectly. So that's been dealt with, and basically it has been dealt with, because she did make some pretty, she made some mistakes about how she handled the court records, and she has fixed that. I
have a question, because I think some people would wonder this, and frankly, I mean, I wonder this, is a judge, how serious is a mistake like that for a judge? Is it something that like, no, that will continue to follow her throughout this case? Or is it a situation like, once it's fixed and the judge shows a willingness to correct what they were doing, that's sort of the way things go? I mean, like, how damaging can a mistake like that be?
It's not that damaging. No one can reasonably expect for any trial to be perfect. No one can reasonably expect for any judge to be perfect, or any prosecutor or any defense attorney. We're all of us human beings, and sometimes we make mistakes. Sometimes they involve us accidentally filing things the wrong way, or not filing records the way we should, or misremembering the name of Roswell, New Mexico, which is especially egregious.
Or handling the microphone in a way that appalls and shocks any professional.
But it only becomes crucial and an issue if the mistakes that are made fundamentally impacts and impairs the defendant's right to a fair trial. And the ability of the public to access court records is serious, and it was worth being handled by the Supreme Court, but it didn't really fundamentally impact Richard Allen's right to a fair trial in my mind.
And if the issue persisted and it was just one of those things that kept dragging on, then I would say that, yeah, that could be problematic for her. But if it's a situation where it's like, oh, that's an issue, corrected, it just feels like, okay. Do you think it's normal for the defense attorneys to be constantly sort of bringing up issues that have essentially been litigated or resolved?
In an earlier episode, I compared it to like a greatest hits album. They just seem to be going back to the same well over and over again. And one thing that does is it kind of creates the impression this is all they have. And you would think if they had some strong arguments to make, either about unfairness or about evidence or what have you, they would be making those arguments instead of going back to the same well, which is, in most people's mind, has gone dry.
And I feel personally like it's just been a huge waste of time, a lot of this repetitiveness. And because I think they should, if they have an issue, I think they should get it on the record, make a filing, make a record of it for an appeals court. That is important. That is part of their jobs. So I'm not saying, don't file. It's just a lot of things have been filed, I feel like 500 times in this case. And it's sort of like, can we just go to trial? Like, can we just kind of be ready? Can we be professionals and be ready to go to trial and do this and maybe like be looking at the discovery we have and trying to figure that out instead of whatever this is? That would be great.
Fair.
So
what's next?
Is this, I'm just want to make sure I'm, okay. So this is about,
you want me to read it?
Differing treatment. No, I got it.
Okay.
Quote, counsel claim their motions are treated differently than those motions filed by the state. The court has set hearings on pending motions, which have now been continued due to the filing of this motion to disqualify. When defendant files pleadings, the state is entitled to file response. The court follows trial rule regarding time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's responses. Once the issues are closed, if a hearing is required, one will be set. End quote. So what's this about again?
They were saying that you take a long time to grant us hearings when we request a hearing. And she is saying, well, there are rules, and that if you make a request for a hearing on a specific issue, I have to give the prosecutor time to respond to that. And then you're given time to respond. So I'm not going to schedule a hearing unless, number one, I think it's warranted. And number two, once both sides have had an opportunity to respond to the request. I'm just following rules is her argument there.
I personally have felt that she has taken an awful long time to rule on certain things. That's my personal view. So I do somewhat share. I personally do not believe that it's because she's just biased against the defense. I just feel like she's often taken a long time. But I think what she's saying here makes sense. Ultimately, she's bound by the rules and ensuring that I would prefer a judge to ensure that everybody has a chance to respond properly rather than just kind of going off and saying, well, boom, like, here's what we're going to do. And then like having it be a problem later. So I tend to think that's prudent, even though I can understand the defense's perspective where it's like, this is taking forever. Can we just know what's going to happen next? So I think I can understand both sides there to a certain extent.
Let's get back to the document. Quote, defendant asserts that the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6, 2024, defendant filed a motion for speedy trial. The court granted that motion on March 7, 2024, and set the case for speedy trial March 13th to 31st, 2024. On April 30th, 2024, defendant filed a motion for a pretrial hearing, which the court set for hearing on May 7th, 2024. At no time prior to the May 7th, 2024 hearing did defendant advise the court that 3 weeks for trial was inadequate. At no time prior to May 7th, 2024 did defendant indicate belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. While the court agrees continuance of the trial is harmful to the defendant and the state, it could have been avoided had counsel communicated prior to May 7, 2024. Counsel represent they notified the court on or about October 4, 2023, that they would need 2 weeks to present defense, but the court has no record of that communication nor any recall of such communication. Counsel's assertion that between all defense counsel with combined 70 years of experience, not one time have they been told the trial would absolutely end on a certain day and not go any longer, is irrational and unreasonable. The court is aware its colleagues across the state routinely give trial dates to begin on set dates and end on set dates. Unquote.
All right. This is where she's getting a little bit more fiery, I think. Like not like super fiery, certainly compared to some of the other dramatics that have been in this case, but
Irrational and unreasonable.
yeah, for her that's pretty intense.
She's saying that they said that no one ever sets exact start and end dates for trials, and she's saying, well, I'm well aware that other judges in the state do that.
And I mean, so am I. Like, you see that all the time.
Yes.
We've actually had a lot of defense attorneys talk to us and say, like, they're shocked that it would be given that much time.
Yeah.
You know, I think people have a perception it's an important case. There's a lot of witnesses, and that's all true. But I think people who are actually in the business are thinking, like, this does not necessarily need to be treated extra special. I don't know. It's kind of there's an odd sort of quality to some of the defense filings around this, because it's like the way they talk, you would think that most defense attorneys were like carried into court on like velvet cushions and just completely bubble wrapped on everything. And these cases, like, people are expected to, you know, not go, you know, run around the courtroom like for 2 weeks, doing everything under the sun without even really knowing if they're going to be able to put their odinous defense on. I don't know. It's just an odd discrepancy from what we see with most defense attorneys.
Yeah, and she's indicating if they had communicated earlier that they needed more time, that could have been arranged.
I would tell you, like, I personally do not believe that they ever had any intent to go in May. I think the fact that they had a carte blanche, essentially speedy trial document ready to go, signed by Alan without a date on it, tells you everything you need to know. I believe that tells you that they were essentially, this was a strategic move. I think personally, the timing to me indicates that it was possibly linked to the fact that they were facing contempt charges and maybe had concerns about whether they'd be remaining on the case. So, okay, you file a speedy motion to say, like, it would be totally outrageous to throw us off now. I don't think that factored into Judge Gull's ruling to not find him in contempt, by the way. I'm just saying that I think that was calculus that they were doing. And the result of this is that it just wasted everybody's time, and her docket was cleared for no reason. And I think if there had been no issue around timing, they would have found another reason to continue it. That's just my personal opinion. I mean,
right.
You don't have to agree with me. I'm looking at the totality of actions by the defense in this case, and I'm looking at the fact that they were like desperately calling possible quote unquote odinous experts in like mid-April
For a
trial in mid-May, and I'm saying, yeah, that was not going to happen.
And of course, the defense also complained that Judge Gull was not guaranteeing that they received the same amount of time to present their defense that the prosecution might receive. Her reply to that is, quote, "The court is not required to guarantee equal time for both the defendant and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their case, however long it takes. Had counsel notified the court within days of receiving the March 7th, 2024 court order setting the case for speedy trial, March 13th to 31st, 2024, that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th to June 14th, 2024. Trial is now set for October 14th to November 15th, 2024, as requested by the defendant," end quote. So she's saying, I scheduled it for a certain amount of time. If they knew that was not enough time, they could have let me know and I would have changed it. But they did not let me know until much, much later, when it was too late for me to change it under the rules as I understood them.
Yeah, and I mean, like, it's sort of I gave a vacation example in our some previous episodes, but like, if you say, Anya, we're going to go on a 2-week vacation, and I say, great, and you're going to say, it's going to go from this day to this day, and I say, awesome. And then, like, after you book the flights, I say, no, it needs to be 4 weeks. Then I think maybe I'm perhaps not being super reasonable there. And then, frankly, it makes it look like I never really wanted to go on the vacation of you, and I'm just desperately trying to get out of it. So it's
hey,
get me. Yeah, I don't know where would you take me where I would pull a stunt like that. I think I enjoy vacationing with you, so probably nowhere.
Thank you.
You're welcome. I'll throw you that bone.
Thanks for the clarification.
I don't want anyone to think that we're having issues. He's a delightful traveling partner and a delightful companion and a delightful person to work with. So here's one thing I want to say, though. This is more from the other section, but I think you and I have both criticized Gull at times for record-keeping issues, especially around like documents and whatnot. One thing I think is really interesting is she says she has no recollection or no record of communication from the defense for an October 4th, 2023 statement around we need more time than 2 weeks. And I think that's an indication there have been record-keeping issues on both sides, but that underscores the importance of everyone putting their stuff on the record so that you can
I think any time attorneys for the case communicate with a judge about the case, it should be written or it should be in a meeting where a court reporter is recording it or something, because then issues like this could be avoided.
Yes. I think that's really important.
Shall we move on?
Yeah. So the next part is, quote, counsel accused the court of engaging in extrajudicial activity. Counsel is correct that on July 9th, 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about their team winning the tournament. The counsel's allegations in this part of their motion are well-founded regarding potential witnesses' alleged social media activities and are presented to the court for ruling. The court will rule accordingly. Concerns about anticipatory rulings are not reasonable.
Yeah, this unquote. This you recall, they said that they alleged that a therapist of some sort in this case who might offer evidence against Richard Allen, they accuse of being involved with some Facebook groups inappropriately in their mind. And they're saying, well, we can't expect Judge Gull to rule on that favorably because she once congratulated her former daughter-in-law about winning a game. And she's saying, no, wait until I actually make a ruling. And if what you allege is true, we'll see what happens. You can't ask me to recuse myself based on how you think I might hypothetically rule about something a month from now.
Yeah, it's like anyone who deals with anticipatory anxiety, it's sort of like that has no place in the courtroom. We're dealing with facts. We're not dealing with what you think might happen if this eventually. And also, I mean, yeah. And just as the ruling says, or as the order says, like there's a question about what will even be admitted. If it's a bunch of conjecture about this witness's Facebook post without any real basis, then that might not even be involved. If there's something concrete there, then we can cross that bridge and see what happens. But, yeah, just legally speaking, that seems pretty fair and reasonable.
Now, I think the next section is very interesting. I'm sure you will all remember that there was a hue and cry raised by the defense counsels and their supporters online, alleging that Judge Gull was refusing funding for experts. And this was seen as so egregious and so unfair that there was actually an online campaign waged where people could donate sums of money for the defense, supposedly to hire experts to work for Richard Allen.
Because the judge was depriving them of the money to do so.
Right. And this fund was being run by David Hennessy. And so all of these, I believe close to $50,000 was given to David Hennessy because they need this money for experts. What did Judge Gull have to say about these claims?
Quote, defendant asserts the court has denied reasonable requests for funding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to is for $26,000 for investigative services from June 4th, 2023 through October 16th, 2023, was in fact returned to counsel as no documentation was provided for services. No documentation was submitted until quite recently. With that proper support and documentation, the court authorized that invoice for payment on May 17th, 2024. Sound effect. This is outrageous in my opinion.
So the reason they weren't getting funding was because they were handling the requests improperly.
And let me just say, Carroll County is footing the bill for this. The Carroll County taxpayers are footing the bill for this. There absolutely should be safeguards and checks in place to ensure that they're not getting bilked for and being on the hook for a bunch of nonsense. This is, again, this taxpayer money is paying for this. When you're dealing with that, you need documentation, you need support for what you're asking for. In no world should anyone just be able to snap their fingers and get a big Scrooge McDuck-esque bag full of money in this case. And I would think that in most instances, defense attorneys would be more than happy to properly file their documentation to ensure that they get paid and their experts get paid and that there's no issues. But this just strikes me as yet another instance of this defense team doing their jobs improperly and then turning around and blaming everyone else. And what is egregious to me in this situation is that then members of the public hear, their, team members going out to the media and complaining about not getting money and being, mistreated by this evil judge. And then they give over thousands of dollars, which are now going to be, I guess, in David Hennessy's pockets. I mean, where's the oversight? Where's the oversight for those thousands of dollars? Where is that going? Who has that now? And what are they using it for? And the thing is, with taxpayer money, there's oversight. This money is going to this specifically. But when we're talking about this shadowy, bizarre campaign that not even GoFundMe would take on, I think the whole thing has a very grifty air to it. And I find it very disturbing that now we're hearing, no, you just filed the paperwork wrong and you didn't do the work you were supposed to do. I mean, I think this is outrageous. And if I were one of the people who handed over money that I earned to this campaign, I would feel incredibly cheated.
People who donated, I'm sure in good faith, felt they were donating to support the rights of the accused to receive adequate funds to conduct a defense, and apparently they were actually donating for the rights of attorneys to get funds for experts without having to do paperwork.
Yeah.
Sum it up.
Don't you think that that's a righteous cause? I think we should have an awareness month about that. For lazy attorneys who don't have the ability for some reason to do basic paperwork again and again in this case, or find their own discovery, or handle Odyssey correctly.
Should I move on?
I'm just gonna say this. Like, this is not normal. This is not normal behavior from defense attorneys. And the fact that they allowed David Hennessy to do this, unless he just unilaterally did it on his own, I think is really that's not a good look.
To move on, quote, defendant complains that public confidence in this case has eroded. His counsel should know criminal cases are tried in courts of law, not in the court of public opinion. An independent judiciary requires the judges decide cases according to the law and facts, without regard to public clamor or fear of criticism. The court continues to receive ex parte communications from the public, criticizing the court both personally and professionally, and threatening the court with bodily harm and injury. The court continues to provide these communications to the parties. The court is not interested in memes and other social media content that can be easily located on the internet. The court cannot be swayed by inappropriate and ridiculous outside influences, quote, unquote, rather. So at least now we know exactly what the judge thinks about some of the social media stuff, including the emails she's been bombarded with.
She's completely right on the money here, in my opinion. What do you think?
Yeah.
The judge should not be swayed by memes. And the fact that the defense cited memes is embarrassing and should be really looked askance at. And if I were on...
It shows that the defense is spending a lot of time concerned about how the case is going on the internet instead of how it's going in a court of law.
I think the defense is really plugged into this YouTube nonsense, and they don't realize that most people don't watch this. Most people get their news from actual news outlets, and it's just totally a sideshow, and they're basically constructing everything in order to appeal to the dumbest people on the internet and ignoring all the people who are reasonable. Because, I mean, I'm going to tell you, there are people who are sympathetic to Alan who are not in that space.
And they're losing them with
with this stuff.
It's really striking to me in our real life, obviously we walk around, people say, oh, you guys cover Delphi, and they come up and talk to us. And up until a few months ago, I would say that the people who approached us were close to being evenly divided.
Yeah.
People say, well, I think he's guilty. Other people saying, well, I haven't seen anything that would absolutely convince me he's guilty.
Yeah,
yet.
I vote to acquit at this point.
I'm on the fence. But in the last few months, I would say that most of the comments, the vast majority of people who come up and approach us now seem pretty firmly convinced that he is guilty. And a lot of the things they say to us involve criticism of the defense team.
And it's like they're so obsessed with how they come across to the media and to social media. But by doing that, I think the thing that would impress people would be to put on a strong case, do what you say you're going to do, and get it done. I think that would impress a lot of people. And that has consistently not been what they've done. It's just been basically everything else is what they're doing. And people aren't stupid. People are sophisticated. They realize that when defense attorneys are doing this, they have a very weak case. And that's what they're telegraphing right now. And I think it's a disservice to their client. And I think they've courted a lot of this crankery online. And I think it's off-putting to most people. And I'm going to tell you, everybody sending abusive things to the judge and everyone, with these threatening, rude emails should be embarrassed. They should be embarrassed. And frankly, their families should take them aside and tell them to stop embarrassing themselves. The more polite emails that are less abusive, I'm sure those people are well-intentioned. They don't seem to understand that it's not a popularity contest. It's not American Idol. Texting in your vote to the judge, your opinion does not matter. It doesn't, nor should it. We don't want to be in a system where judges can be swayed by some, highly aggrieved people on the internet. It sounds good because it sounds democratic, but at the end of the day, it turns into mob rule pretty quickly. If I'm facing something, it goes both ways. It could be something pro-defense, but if hypothetically a case where a lot of people were, pissed off at me on trial for serial theft, I would not want them to be able to, send emails to judge being like, throw her in prison forever, like that, because it's like a hot button issue for some reason. We don't want that. And I think it sort of shows an embarrassing lack of understanding of the situation that you have so many people reaching out. It sort of strikes me as a lot of these people just sort of want attention from everybody, and they figured that this is a way to do it because, people are following Delphi, and it's an email from True Crime Swine 69. Let's see what he has to say. And I don't think I don't know. I think she absolutely should be ignoring all of this. It's nonsense. And I think it's just shocking that the defense keeps citing these people as if it's supposed to be convincing somehow.
And one of the last emails she received was supposedly from Hamilton Berger, who's a character in the Perry Mason stories.
See, I'm not mad about that one because that's a good reference. I'm not gonna lie.
I've started reading recently some of those old Perry Mason books, and they're not good, but they're good. You know what I mean?
They're good.
They're not good.
You love them.
They're very.
Oh my god.
They're not literature.
Why are you trying to? Oh, they're not literature. So pretentious. Just enjoy your Perry Mason novels, okay? Goodness gracious.
Back to the document.
This man constantly. You've been enchanted by the storytelling of Earl Stanley Gardner.
Quote. Defendant further claims the court has refused to order the state to comply with discovery rules. The court has set defendant's motion to compel and motion for sanctions for hearing, which has been continued due to the filing of this motion to disqualify. The previous defense motion to compel was denied without hearing as it was unsupported by evidence, unquote. So she's saying, you said you have some issues about how the prosecutor is handling discovery. You said that before. I didn't think you had enough evidence to warrant a hearing. This time I thought, well, maybe you do have enough evidence to warrant a hearing. And I scheduled that hearing, but I had to continue it because you filed this motion asking me to step down.
One consistent drumbeat in her order has been, well, we would have gotten to that, but you asked me to step down, so it's going to be delayed. Next portion, quote, defense counsel alleged bias by the court, only allowing cameras in the courtroom on one occasion. Court has not allowed cameras in the Carroll Circuit Court due to its limited size and layout. Court did allow cameras in the Allen Superior Court at the hearing conducted on October 19, 2023. The hearing was not conducted and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. Court lost confidence in the ability of the media to cover hearings appropriately.
End quote. I think you have some stuff to say, and then I have something I want to say.
I have some stuff to say. I'm really just, I don't know. The media aspect of this case has just been something that has been consistently, frankly, frustrating for me. So Court TV was the outlet assigned to pool coverage at that hearing. We've tried to figure out what happened, and behind the scenes, I don't think anyone really knows what happened. So it would have been nice for Judge Gull to outline what exactly did Court TV do wrong here, because I really cannot figure it out. We've heard rumors, but we've not seen anything confirmed, and the only really way to get something confirmed would be through the judge at this point. So this is annoyingly vague. In addition to that, I think it is deeply unfair, even if, and I'm saying if Court TV did something wrong, I think it is a bit unfair to blame all the media for one outlet's possible mistake or bad actions. That does not seem reasonable to me. I think there are a number of media outlets in this case who've done a very good job of covering the case. And I think a lot of them are local. I believe they can be trusted to cover it in a reasonable manner through cameras in the courtroom. I think they have the ability to do that. And I don't like the implication of essentially saying, well, one media outlet may have messed up. I'm not going to tell you exactly what they did, but therefore all the media have lost my trust in covering it. The judge is not a media critic. She's not a media expert. Okay, you go ahead.
That was my part.
I'll hand the baton to you.
I was really, really upset by that last line. The court lost confidence in the ability of the media to cover hearings appropriately. Why on earth does Judge Gull think she is a media critic? Why does she think that is her function? It is not. Her function is to protect the rights of the accused man, protect the witnesses who come in, and try to ensure a fair trial. It is not up to her to be a media critic and decide what is appropriate or what is not appropriate. The way she has handled the media at these trials, she is really limiting the public's access to these proceedings and their ability to learn what is going on. To me, this is probably an offensive comparison, but it would be like if a judge rules that a person doesn't have to pay child support because the mother has misbehaved. The child support is for the child. Right. It's not for the mother. And in this case, even if one member of the media did misbehave, you don't punish the whole media, because the media is basically a stand-in for the public. The public has a right to know what's going on in these proceedings. The public has a right to know what's going on in these trials. We don't need to have a judge say, well, you only get to find out if you do it appropriately. That I found that very troubling and very upsetting, and I think it really illustrates a lot about Judge Gull's attitude towards the press and the media in this case.
I just think it's I think when you have a vacuum, when you have a power vacuum, that the vacuum is going to be filled. And when you do not, to a certain extent, roll out the red carpet for legitimate media outlets that are doing a good job or being fair and have professional standards, that's when you get TikTokers and YouTubers who come in and do a bad job. Not saying that all TikTokers and YouTubers are going to do a bad job, but you do have a lot of them who are doing a terrible job, and they basically feed conspiracy theories because people are not getting it from legitimate outlets. They're going to turn to whoever's covering it. Legitimate outlets are not going to cover something in depth if they don't have access. It creates a problem, and I just don't think I personally find this very unfair, and I don't understand it. I think she could have made an argument that focused less on maligning the media and talked about the sensitivity of the case. The fact that it's already such a circus, I feel like I'd be safeguarding it by taking away cameras. And that's my thinking on it. There was a way to handle it in a way that kind of tells me, well, it's more about safeguarding as opposed to like, I'm punishing the media because somebody made an oops at one hearing. I don't know what Court TV is alleged to have done, but if one, maybe then they don't get to be the pool person anymore, but you can have someone else take on that role.
You don't take away the ability of the public to have a full understanding of what is going on in one of the most important trials in the history of Indiana based on something vague you suggest that one media outlet did. And I'm interested in what Judge Gull has to say about legal issues. I'm interested in what Judge Gull wants to do to safeguard witnesses. I'm interested in what she has to say about safeguarding the rights of Richard Allen to a fair trial. I'm interested in all of that. I am not interested in her opinion of what does or does not constitute appropriate media coverage, because that is not her role.
And like at this point, I'm going to tell you, I believe that there should be cameras at this trial. They're not going to be. So I'm kind of just like, okay, but I believe there should be. But I've become increasingly sympathetic over time, seeing some of the grandstanding and seeing some of the nonsense in this case, to the idea that maybe there shouldn't be. And that, with the, the TikTokification of like, let's analyze this person's facial expressions. Do I want to see Delphi go through that? No, I don't. So even though I'm very much a stringent believer in cameras in the courtrooms, I'm sympathetic to the opposing point of view. But this is not a good reason.
No, it's not. And I mean, also, I think it's important to note, it's not like a binary choice. It's not like I would say, well, either cameras in the courtroom or no concessions for the media at all, or for the public. There are all sorts of compromises. What about having audio? What about letting the public hear audio? What about guaranteeing reputable news outlets to be able to go in and take notes and provide thorough coverage of what happens?
Yes.
Right now, it's basically, if you want to get in, you have to show up at like 4 or 5 in the morning, and you're not even allowed to take notes on an electronic device. You have to do it on notebooks.
Yes.
It's odd.
I completely agree. To me, I think in this case, a reasonable outcome would be no cameras, but you have a number of rows of media seating. You curate that and ensure that people who are reputable are in that. And you make it easy for them to have assigned reserved seats. They're going to cover it. There's going to be different views in that. And they're going to do a good job. And that will give the public a sense of what's going on. You don't make it this sort of anarchy, Lord of the Flies, line up and worry that you're going to get punched by some deranged YouTuber, who has some sort of issue with, another deranged YouTuber. You have it be, if you're accommodating the media in a different way, even if you don't want cameras. And I don't think there's been any will to do that. And I think that's a mistake, because I think that's just going to engender more conspiracy theories.
And again, the media is the surrogate for the public. Because,
yeah, it's not about like, oh, reporters are more important than everyone else. It's reporters are going to be able to tell the public what's happening.
Because you people listening now, all of you care passionately about this case. You're not going to be able to walk away from your jobs for weeks or for days or whatever to go and attend these court hearings. You have a right to know what's going on, though. So the way to do it is to send qualified people, qualified media to go in and report on it.
And you would rather, I'm just going to say this, you would rather qualified media people doing this than some guy who
Swine Crime 85.
Swine Crime 69, who's gonna come in and just do a horrible job and, talk about how he believes Judge Gull is an Odinist and all these other YouTubers he's feuding with is an Odinist, and his ex-wife is an Odinist. That's why she's going after all his money. I mean, like, that's not what we want at this point, but that is what we are going to get, because there's a decent possibility he's going to get in randomly over some like qualified reporter who's going to like tell you what happened. And that's not a good situation. And that is engendered by the sort of lack of media support in this case. I think it's a huge mistake. And I think, frankly, I have so many ideas about areas around media relations that have gone wrong in this case on all sides, that I feel like I could write a textbook about what not to do on all sides.
Well, let's move on and wrap this up. Quote, "The court has issued adverse rulings against the defendant as well as against the state of Indiana. Adverse rulings do not support reasonable basis for questioning the court's impartiality, nor the grounds for disqualification. They are just adverse rulings," end quote. So she's saying, just because I've sometimes ruled against the defense doesn't mean I'm biased. I'm just applying the law as I see it. And it is basic law 101 that it takes more than adverse rulings to demonstrate that someone has a bias, because any lawyer in any courtroom is going to sometimes make motions or such that are going to be ruled against by a judge.
If it was based on adverse rulings alone, then in a world where Kevin's a terrible attorney, he could go into court, trip over a bucket, send in a crayon filing, and just do a terrible job, and then he'd be able to argue, well, they kept ruling against me, so obviously they just hate me, and no one would be able to be like, no, you just did a bad job.
And I like to say I like it better when the comparisons, the metaphors are about you stealing cereal.
Well, I think you need to, if you're willing to dish it out, so to speak, or bowl it out to go with the cereal metaphor, then you need to be able to take it.
What else? Let's wrap this up. Is that it?
What do you think about the filing overall? I know we've criticized elements of it pretty harshly. I think we've agreed with elements of it pretty readily. How do you walk away? What do you walk away with from this filing?
I find it frustrating. I find it frustrating that the defense filed a third request to remove Judge Gull, because no matter what you think about Judge Gull, I think it was pretty clear. She rejected previous motions to be recused. Why is she suddenly going to say, oh, I guess he made a point, I'm going to recuse myself? She's not going to recuse herself. There doesn't seem to be any real reason for her to do so. So it feels like we wasted time, and 3 days worth of hearings were continued because of this. And they were important hearings that needed to be held prior to this trial. And so it just seems like we've delayed to get to a result we all expected, and we just wasted time.
I'm going to tell you my thoughts. I think this codifies for me what the defense is going to be doing going forward, which is delay. I mean, this is what they're going to do. This was not about record keeping or having a record for appeal, in my opinion, because their latest recusal attempt was completely repetitive from past attempts. They acted like it wasn't, but as Kevin said, it's the greatest hits, right? We're hearing the same song over and over again. And I think I believe that I certainly have criticisms of Judge Gull's handling of aspects of this case that I strongly disagree with and will continue to criticize. But generally, I did not see any reason for her to recuse herself. To me, a lot of the media issue is more of our own personal bias towards, freedom of information and things like that. But they would not prompt me to say, and therefore the judge should recuse herself. That has to come from like there's certain parameters that I think you have to cross in order for that to be recommended. And I think that the Supreme Court of Indiana essentially cleared her to a certain extent, because they basically said she's been fair. We just disagreed with her taking the attorneys off when she dismissed them. We're putting them back on. Issue solved. I personally believe that we may see more delays, because I think there is a decent chance that they are going to now turn to the Indiana Supreme Court, or maybe like an interlocutory appeal.
Yeah, I've seen some indications that at least you never know who to believe on this, but there's certainly some people online predicting or claiming that the defense's next move is to take this to the Supreme Court or a lower court, demanding that Judge Gull be removed from the case. And I hope that those predictions, or whatever you call them, are not true. It would just be a further waste of time.
I think they're true.
And I feel that the families in this case, they have waited so long for justice. And if the case against Richard Allen is weak, as the defense attorneys like to say it is, let's just get it tried, and let's get an answer. Let's get him either acquitted or get him convicted and move on. It has been far too long of a wait.
Do you think that a higher court would kick Judge Gull off based on what we've seen so far?
No.
I think it's a complete pie in the sky request. I think it would just be a delay tactic. I mean, I think it's basically stall until we figure something else out. I think that's the name of the game now. I think we all should be braced for a very long road ahead, because I think this is going to drag out, and it's going to be dragging out not because of necessarily legitimate complaints. It's going to be dragging out over very frivolous requests that seem just frankly outrageous to even contemplate at this point. if they have such an issue with Judge Gull, they've made their record for appeals. I don't think it would go anywhere because I don't think anything she's done rises to that level. But I just think it's just about delaying at this point, and that really underscores that you cannot just believe, bravado when a prosecutor or a defense attorney is talking about, like, we have this great case, and then they're delaying or they're obfuscating or they're exaggerating. They don't have a great case. They're just saying that because you don't do that when you have a slam dunk.
No.
You do that when you are scrambling to figure out how the heck we're going to get around all of these incriminating statements and confessions by our client, who seems very much inclined to admit guilt for whatever reason. And, we're not filing anything around mental health issues around that. So, what is the explanation? And one thing, we heard from our friends, the prosecutors, Brett and Alice. Our friend Jason Blair asked them a great question that we were talking with him about. I shouldn't call it a great question because it was our question, but it was a question that I think.
So full of yourself.
I'm just overconfident over here. But I so appreciated him asking them this. And it was basically like, could there be some sort of independent counsel appointed to investigate whether or not he wants to go forward? And they indicated there are problems with that. And I totally see that. But their response was essentially, it might be a situation where it might behoove Judge Gull to essentially like arrange a situation where she can talk to him and just ask him questions. Are your attorneys listening to you? Do you want to do this? Do you understand your rights? Do you understand what you're able to do? And just ensure that he's on the same page. We very much could be looking at a situation where he at one point wanted to plead guilty and he was, feeling that way. And then he changed his mind. It's actually, I want to go to a jury trial and have all of this dragged out. That is totally within his rights, and he can change his mind. But I think it needs to be established that that indeed is the case and that he's not being essentially dragged through this, because that is not fair to anybody involved if he does not want this. And to me, when a man is confessing again and again and again and again, that's a sign that not only does he perhaps not want to go to trial, but that it feels unheard, feels that people who are supposed to be listening to him are not, and that he needs to unburden himself to whoever will.
Exactly. Well, thank you all for listening, and we'll talk again later.
Thanks, everyone.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.
There's nothing worse than getting home from your trip only to find you missed a can't-miss travel experience. That's why you need Viator. Book guided tours, activities, excursions, and more in one place to make your trip truly unregrettable. Viator makes it easy to explore over 300,000 travel experiences, everything from simple tours to extreme adventures, and all the niche, interesting stuff in between, so you can plan something that everyone you're traveling with will enjoy. Real traveler reviews give the inside scoop from people who've already been on the experience you're considering, so you can plan with confidence. Free cancellation helps you plan for the unexpected. And 24/7 customer service means you always have support around the clock. Download the Viator app now to use code Viator10 for 10% off your first booking in the app. Regret less. Do more with Viator.